Right, everybody. I think we're going to start. Um, Welcome to this information sharing session, and we want to keep our information sharing sessions down to 45 minutes if we can. Let's see how it goes. So we're talking today about quite a tricky subject, and when I say tricky subject, what I really mean is the approach by trade unions to your company to represent your employees to you, and how sometimes there is a tendency for them to get carried away with themselves and to essentially pretend to have a whole lot more power, but also a whole lot more entitlement than necessarily they've got in reality. So let's get to it. And certainly, some of you have had a lot more experience than I have had within your companies. And I think this will lead to quite an engaging and hopefully meaningful interaction and discussion. So let's talk firstly about this issue, and that is
Sorry,
general
Ivor.
right. Yes.
Can you just request that all microphones are just turned off, just yours is on for presenting?
All right. So, colleagues, please, if you can mute your microphones, that would be fantastic. Thank you so much. Okay, so number one, can an employer refuse access to a trade union? Well, the simple answer is no. Section 12 of the Labor Relations Act says that a representative trade union has the right to access the workplace for recruitment, for consultation, and to provide services to your members. So you cannot stop a trade union um, from accessing the workplace as long as there is a pre-arrangement with the workplace. And that pre-arrangement can either be by way of a agreement that there is not sufficient the representation for a recognition agreement to be entered into, but certainly sufficient representation for organization and representation purposes. And we'll get into that in a little later. But if a trade union has not prearranged, has not told you they exist, and automatically want rights to access your workplace, you can say no, you do not qualify in terms of Section 12 of the Labor Relations Act because you're not a representative trade union. You've not given us proof that the employees have joined your trade union, that they want us to deduct debit orders, and we've not begun deducting debit orders from them. So, Section 12 states that a trade union has the right to enter employer premises for member recruitment and communication, provided it does not disrupt operations, and like I say, provided that they have actually entered into an agreement of some sort with you to recruit your employees as their members and to begin the process of servicing them. Many companies use pre-agreed access protocols. In other words, having a policy in place that says that what you should do is sorry, I just want to see what's going on here. What you should do is A, B, C, D, E in terms of your first encounter with the trade unions and in terms of any follow-up encounters you have with those trade unions. So what does representative trade union mean? Well, the Labor Relations Act isn't strictly defining what a percentage is. But case law suggests that anywhere between 30 and 40% of your membership is sufficient for organizational rights, not bargaining rights. In other words, if they have up to 40% representation, they can continue to represent your employees and in things like, sorry, they continue to organize your employees to try and get to a higher percentage, and they have rights of representation, which means that in disciplinary inquiries, in counseling activities, and in dismissals, they have rights of representation as far as your employees are concerned. Case law suggests, and here we're talking about National Union of Mine Workers versus ESCOM many, many decades ago, but it's not really been overturned, that sufficient representation depends on context. In some companies, you might find that 30% is sufficient. And in other companies, you could insist that 51% is what sufficient representation actually means in the workplace. Rob, let me ask you, in your workplace, what is your policy in this regard?
How's it, Ivor? Yeah, we go by the 30 to 40% representation.
So we've got to be very specific here. What you say then is if you represent 30 to 40%, we will give you organizational rights, we'll give you representation rights. Do you have a plant-based agreement based on those percentages?
No, we don't. When they go to the higher percentages, 51 plus, then we start looking at it, yes.
Okay, excellent. Charmaine, from your point of view at Becker's, how do you deal with this issue?
Either we also have the 51%.
So you're saying to them that you can have rights as a trade union to organize our employees as members if they're prepared to join you. We will recognize you as representing their interests in inquiries and everything else, but we're not going to give you a bargaining agreement until such time as you meet the 51% requirement, or we're not going to give you a plant-based agreement because we are members of the Surface Coating Employer Association, which is a party to the bargaining council, and as such we govern our activities by the sectoral agreement, the industrial chemical sectoral agreement in the bargaining council, and therefore we don't want any plant-based agreement. Is that correct?
Yeah. Yes.
All right. I do want to actually just let me deal with this issue of plant-based agreements and get it out of the way. If you are party to a bargaining council, and being party to a bargaining council means that you are a member of the Surface Coating Employer Association and therefore party to a bargaining council. If you're party to a bargaining council, you are not obliged to enter into any plant-based agreement with any trade union. And so I want to reiterate this because there are some trade unions that have forced some member companies to enter into plant-based negotiation. If you fall under a bargaining council, you're not obligated to enter into a plant-based agreement. However, it really is contextual and it really is subject to the pressure you're prepared to absorb from the trade unions, because some trade unions, and I think of NAMSA here in particular, are particularly assertive in that regard. And you just have to have the nuts to reject that level of assertion. In the absence of them being a member of the bargaining council, then in fact the trade union is entitled to pressurize you to recognize them and with sufficient representation to enter into a plant-based agreement with them, but there's no prescription as to what should be in that plant-based agreement. So if you are not going to give them bargaining rights and they cross a threshold that you're agreeing on, or a threshold which is common practice, then in fact they have a right to pressurize you to enter into a plant-based bargaining council agreement. The question is, can minority unions demand organizational rights? And the answer is absolutely. Any trade union that represents that 30% is entitled to say to you, we've organized 30 of your 100 employees. We would like the opportunity to try and organize more and to provide the 30 that we have organized with services. And you cannot say no. And that goes back to a ruling in 2003, the NAMSA versus Badebop ruling, which confirms that minority unions can strike to obtain organizational rights if you're not prepared to give them organizational rights. And then once they're organized, can strike for the recognition that they have a right to a recognition agreement. What happens if an employer refuses to deduct subscriptions? I've seen cases of, let me call them bitter employers, that feel that they've been forced into a situation with a trade union they'd rather not be in, and they refuse to deduct union subscriptions. And the Labor Relations Act is specific. If you have a form from an employee to pay a deduction over to a trade union, 100% the company doesn't have to subsidize that 1 cent. But if there is a request by an employee to pay a trade union a fee every month, you've got no choice. You have to deduct. and you have to remit the union fee to the union if the employee has consented in writing. Now, that's Section 13 of the Labour Relations Act, and unfortunately, there are far too many court precedents in that regard saying that you really do not have a choice. So I want to implore you not to play around with that. Employers must deduct fees where a recognized union exists and written employee consent is given. Can employees refuse trade union subscription deductions? Yes, an employee must consent in writing. So, and this happens quite often. It happens more often than you would think, that a trade union is on a conscription drive in your company and someone doesn't want to be seen not to be joining the trade union. So they fill out the trade union membership forms, but they do not give consent to a deduction, to a debit order going through. And so the employers, or year on year, the employee changes their mind. They say, we've been paying all this money over to the trade union. We're not getting value for money. And therefore, we want to stop paying the money over to the trade union. So it has to be in writing. Either to pay or to stop paying has to be in writing. If an employee decides to stop paying, as a company, you're obliged to inform the trade union that that employee has indicated that they no longer wish to be a member, a fee-paying member of the trade union. So you've got to be very careful about how you handle deductions. All right. Now we move to are there any questions about deductions, by the way?
However, is it up
Yes.
to the employee to advise the union that they are no longer wanting to have deductions made, or is it up to the employer?
The moment a debit order deduction, you see, a debit order deduction is a contract between the company and the trade union that because they've got a signed debit order form from the employee, they will deduct and they will remit. If there are any changes to the principle of deduction and remission, a remittance, then in fact what you have to do is you have to inform the trade union that they will no longer be getting a deduction on behalf of Rob Evans because he has signed a document to say he no longer wants to be a member, a fee-paying member of the trade union. So it's up to the company to inform. So the company can't turn around and say, well, why didn't your member tell you that they were no longer your member? Yes, ethically, that's the way it should be done. But in principle, operationally, the company, which is responsible for payroll, is responsible for deductions, has to send a remittance advice back to the trade union that these are the individuals who no longer wish to be part of your trade union, and therefore we're not paying you a deduction any longer for them. Does that answer your question, Rob?
Yeah, absolutely.
Okay, you sound quite miffed by my answer, but I'm just the messenger.
No, not at all. Not
All
at
right.
all.
So now we get to the next issue, which is registration and compliance. So if a trade union, which is not registered with the Department of Employment and Labor as a trade union and cannot present to you a registration certificate, under those circumstances, they're not a trade union. And under those circumstances, you are completely within your right to say goodbye, come back to us with So come back to us with two things. Come back to us with a registration confirmation from the department that you are a registered trade union in good standing, because there are trade unions that get deregistered, but they don't tell you about it, and they continue to sign people up. So come back to us with a current registration certificate from the Department of Employment and Labor, number one. And number two, and companies don't always know this, but number two, prove to us that the scope of your registration covers our industry. Now, there's recently been good precedent in the Labour Court to say that if I call myself a general trade union and Charmaine says, hold on a moment, that's got nothing to do with coatings fabrication or the chemical sector whatsoever. You are not even as a trade union a member of the National Bargaining Council for the chemical industry, which we are party to. You're not a party to that bargaining council. And so we have reason, we've got a right to say to you, you can't organize in our workplace. You can't organize in our workplace because you are not registered with a scope. So another example is that the food and beverage trade unions are trying to go into the chemical sector, trying to go into the manufacturing sector because they're bleeding members. And they are trying to get the registrar to change their name to general rather than food and beverage. And so that hasn't been done yet by the registrar, and they have no right to be playing in your sector. And you're entitled to say to them, we reject the fact that your scope, your trade union scope, has nothing to do with our company. You've got to prove it's got something to do with our company. So you need to have the staying power sometimes to be emphasizing that point so that you're not taken to the cleaners. So registration under Section 95 of the LRA gives trade unions legal recognition and access for organizational rights. Can an unregistered trade union operate legally? Yes, but without access to LRA protected rights, which is they can operate as an association, but they don't have any rights to organize in your workplace. How long does trade union registration take? Normally 2 to 6 months, but sometimes, and this has happened more recently, because every Tom, Dick, and Harry is now trying to form a trade union. Sometimes it can take a lot longer because they just don't have the credentials to satisfy the Department of Employment and Labor. And they can't turn around to you and say, yes, well, here is a letter to say that our registration is in progress. We're not interested in progress. If you're not a registered trade union, come back to us when you are. Can an employer refuse to engage with a registered union? Only if the union lacks sufficient representation or the scope of the trade union doesn't cover your company or your industry. So what happens if a union doesn't comply with its own constitution? You're entitled to say to the trade union, please send us a copy of your constitution. And so if they send you a copy of the constitution and you've got grounds to say, you guys are not even acting in terms of your own policy, in terms of your own rules, you can then go to the registrar in the Department of Employment and Labor, and you can ask them to deregister their trade union, and they will consider it. Access to information and your responsibility as an employer. So Section 16 of the Act requires employers to provide all information relevant to collective bargaining if you are in a collective bargaining relationship with a trade union. In other words, you have a plant-based agreement with the trade union and they are sufficiently representative. Then Section 16 of the Act requires you to provide relevant collective bargaining information. And what is that relevant collective bargaining information? Well, anything to do with a grading system, anything to do with pay scales for that grading system, and all of the payroll information only of their members, not of anybody else. So that's the kind of information. And then they can say, but we want to see letters of appointment and job descriptions. And again, that falls within the context of what is a reasonable requirement. So you do need to provide information unless it's legally privileged or confidential. Now, you can claim that PAPIA protects us as a company from having to release this information about our employees, but you have to then not have to. And then you are entitled to say to the trade union, the only way we can release this information is if you bring us a letter of confirmation that the employee gives you the right to access that information from us, the company. And so you must play that game, because otherwise they can claim all sorts of weird and wonderful things. Now, they are not allowed to claim payroll information about anybody else in the company beyond their members. So they can't say, well, we want to see how much the CEO makes and we want to see how much the CFO in the organization makes. If they are not a representative structure of the CEO and the CFO, they have no entitlement to that information, and you can reject it. You can reject it on number one, on the basis that the employees they're asking for that information for fall outside of the bargaining unit of your business. And number two, that in terms of PAPIA, they do not have a letter ceding the right to the information to the trade union. Can an employer refuse to disclose information? Yes, but they've got to prove that the information is confidential or harmful. Can a minority union demand access to information? No. Only representative unions can request information under Section 16. So a minority union that represents 10 or 15% of the workforce doesn't have the right to access to information. But a union that has a 30 to 40% organizational right does have only for their members, and a union that has bargaining rights definitely under Section 16 does have access. What happens if an employer provides false information? Well, it constitutes an unfair labor practice. They can go to the bargaining council, they can go to the CCMA, and eventually they can go to the labor court on the basis of essentially misinformation. Can unions use disclosed information publicly? No. If you can prove that a union has misused disclosed information and that they've violated confidentiality, then that becomes the violation of confidentiality becomes a criminal charge, and misuse of information can invalidate any recognition agreement you've got with the trade union. Any questions about access to information? I know that some of you have previously asked questions in this regard because of what the trade unions are asking for. The one thing I do want to say to you is this. If you are in a collective bargaining relationship, in other words, the trade union is properly representative of your workforce, and you've either entered into a plant-based agreement or some other kind of an agreement with the trade unions, and it comes to wage negotiations and they don't fall under the National Bargaining Council, they're not a party to the Bargaining Council, so they rely on the plant-based agreement. They can ask you for your annual financial statements or for your management accounts. And you are entitled to say we'll restrict the information we give you only to payroll information, but certainly not to individual information or other operating information about the company. You are entitled to do that. I must say that in terms of the trade unions within the Bargaining Council, it's only NUMSA that previously has ever played that game in my experience. SAPMA hasn't played that game in my experience, certainly not that I'm aware of. Any questions in this regard? Okay, moving on. So now we talk about majority union rights and responsibilities. So what is a majority union? And the answer is it's a union that represents more than 50% of employees in the workplace. In other words, 51%. Can a majority union exclude smaller unions? And the answer was actually ruled on in 2012, and it's been supported with more recent case law, which said, and that was Satawu versus Maloto, which ruled that the majority union cannot unreasonably restrict minority unions from organizational rights, not representation in terms of collective bargaining, but organizational and representation rights in terms of individual matters. Majority unions can't restrict that from happening. Do majority unions have more bargaining power? Absolutely. Under Section 18, they can negotiate threshold limits for representative organizations to actually get into collective bargaining. You don't have to agree with what they're telling you, but they can negotiate it with you. Can a majority union force all employees to join? No. Compulsory membership not only goes against the Labour Relations Act, but it goes against the notion of freedom of association, which is built into the Constitution. No trade union can come along and say, you have to be our member. No trade union. Even in a closed shop, no trade union is entitled to say to an employee, you have to join us. You have to be our member. In a closed shop, they can prevent an employee from joining another trade union, which has rights in the organization, but they cannot force an employee to join them. It's a violation not only of the Labour Relations Act, but also of the Constitution in terms of freedom of association. Now, what happens if multiple unions claim majority? Well, they can't claim majority because majority is 51%. So the most another union can get is 49%. So it might actually be that you have to ask the bargaining council, if the company is a party to the bargaining council, to resolve that issue, or the CCMA, or go to labor court to verify membership figures. But two trade unions can't both have 51% representation. Sufficient representation. Let's just deal with this a little bit. We have dealt with it. but let's just deal with it a little bit more so you understand that the threshold is um, sufficient representation is normally between 30 to 40% for the rights of organization in your workplace and representation of the individual in the workplace. A non-majority union can claim organizational rights if it's got that 30% threshold. So so if you've got a 51% majority union and another let's say that's NUMSA, and a SAPAWA comes along and says we've got 30% of people signed up, then those 30% can continue to try and organize to get to 40% and to try and take from NUMSA their membership. NUMSA cannot prevent a minority union from having organizational rights in your workplace. The one thing I do want to urge you to do is talk amongst yourselves in terms of networks of companies to determine what the average of sufficient representation is actually. So get an idea. And we tried to do this as SAPMA, but it fell on deaf ears. We tried this about 3 or 4 years ago. We didn't get a response from companies to determine what sufficient representation actually means in your company. We're going to try it again because we do need to know what the averages of sufficient representation for organizational rights are, and then sufficient representation for plant-based engagement are concerned. Because there are a growing number of companies that say 30% organizational rights, and when you get to 41%, we will enter into plant-based agreements with you, because both the trade unions and the employers are seeing deficiencies in the sectoral agreement managed by the National Bargaining Council, and therefore feel it needs to be supplemented with a plant-based agreement. But the question is, at what level, at what stage is it incumbent on you in terms of having to starting to talk to these trade unions in terms of wage negotiation and conditions of employment? What is a shop steward? Well, a shop steward is a union representative elected by members to assist with workplace disputes and negotiations. But what we have to realize is, first and foremost, a shop steward is an employee of your company. And so becoming a shop steward doesn't mean that as an employee, in terms of the job they've been employed to do, you lift your foot off of the accelerator in any way whatsoever as that person's manager. They are paid, and first and foremost, their presence in the organization is because they're an employee. And no concessions should be made to any shop steward in terms of levels of productivity, how they do their job, and what their relationship with their supervisors and managers are. I've seen too many companies, colleagues, actually say that for all intents and purposes, a shop steward has now become the HR manager for this department. Absolute cogswallop. But the reality is that companies do not have the fortitude of saying, it's great that you're a shop steward. And yes, you can organize, and we'll talk about how and when you can organize. But first and foremost, you're an employee. If you don't perform, we're going to discipline you. And if you continue to underperform because you're so busy with shop steward activities, we will fire you. And then you won't be an employee or a shop steward. So you have to take that stance in your company. Can an employer refuse to recognize a shop steward? No. If there is a voting process in place, and you've agreed with the trade union that there will be a voting process in place for a shop steward, and you've agreed on the number of shop stewards, and the employees vote a shop steward into power, then that shop steward is the shop steward. You do not have a say as an employer, but you have a say over the fact that they are first and foremost an employee. And you're entitled to put into any agreement you have with any trade union that if this person takes their foot off the accelerator in terms of their levels of productivity or how they're doing their job, they will be subject to the same disciplinary process, counseling and then disciplinary process in this company as any other employee. They have no preferential treatment. Are shop stewards protected from dismissal? They are protected from dismissal insofar as their shop steward activity is concerned. So they can't be dismissed for organizing other employees. They can't be dismissed for going to pre-arranged trade union meetings. They can't be dismissed for representing an employee at the CCMA or at the bargaining council. But if they don't do their job, they wear two hats. And as the employer, your first and foremost priority with them in terms of the hat they wear is as an employee, not as a shop steward. And they can definitely be dismissed as an employee. Have any of you had problems in this regard historically? Okay, nobody. I just want to see what's in the chat. There's nothing in the chat. Okay, moving on. So, legal functions and time off for shop stewards. So, shop stewards assist and represent employees in grievance and disciplinary proceedings. They monitor employer compliance in relation to employees, that the employee gets paid, etc., etc. And they report contraventions to the company and to the trade union. These are the legal functions of a shop steward. Can they take time off to perform their union duties? Yes. Section 15 of the LRA grants reasonable paid time off for them to organize at times convenient to the employer. So it can be during any formal break, or it can be before work or after work. If they want to eat into production hours in the company, I know many companies that make the concession, but you shouldn't make the concession. The time for them to engage with employees is either in tea times or in lunch times if they're formalized in your business, or before or after work. Any exception you make sets a precedent and then becomes the norm for when they can meet with your employees. And that's it's highly disruptive to your production process. So they can take time off to do that work as a shop steward. It has to be pre-arranged with their manager. If their manager says, hold on a moment, we've got a massive production activity happening on that day, you're going to have to change the time of the meeting. Their employee status takes precedent over their shop steward status. And I cannot stress that enough. And there's no single precedent in the CCMA or the Labor Court that says otherwise. Disciplinary protection for shop stewards. Can an employer discipline a shop steward? Absolutely. They can discipline them not as a shop steward, but as an employee. If, as a shop steward, there are behavioral charges against them, then definitely they can discipline them as an employee who is a shop steward who has acted outside of the bounds of what can be expected from an employee who is a shop steward. So a practical example could be that an employee who is a shop steward has a go at a manager publicly in front of the other employees. That's a behavioral problem. You have a disciplinary inquiry and you fire the bugger. You fire the bugger on the basis that as an employee, there is a code of conduct and he's flaunted his shop steward position to in fact break the code of conduct. I'm very skeptical of the companies that don't apply that rule, or who in fact make exceptions to that rule in trying to curry favor with shop stewards, in trying to get on the good side of the shop stewards. The balance of power often shifts from the shop steward being a Patterson A or a B level employee, where you actually treat them as a C-level manager because they're a shop steward. And it's the management of the company that confuses the role of the employee versus of the shop steward. And if the shop steward plays that card and you succumb to that card, you set a precedent that's almost impossible to walk back. And so I really do ask you, please be conscious of that fact. So if you're going to discipline a shop steward, then yes, you need to notify the union. Then you need to make sure that the shop steward is allowed representation. But if you're disciplining a shop steward as an employee, the representation has to be in terms of the rules of representation in the company. In other words, you're entitled to a representative from within the company. You're entitled because ordinarily you're not allowed a trade union official, where there are shop stewards, you're not allowed a trade union official to represent someone unless you ask them to. Unless you, as an employer, you've said it's better for the trade union to represent you. But you are entitled to say that as an employee, we are disciplining you for your error rate, or we're disciplining you for what you've done in the production process. And as such, you're entitled to a representative from within the company. And you're entitled to fight the notion that a trade union should be entitled to come in and represent a shop steward on employee matters, and therefore invoke the shop steward status as a shop steward to protect them from discipline and possibly dismissal. But it needs a backbone. If there's no backbone, the trade union is going to ride roughshod over you. Can a shop steward be dismissed for union-related activities? No. This would be automatically unfair in terms of Section 187, 1D. However, if there is an unprotected illegal strike, and the unprotected illegal strikers engage in criminal activity, so they burn cars, they intimidate clients or suppliers, then in fact you have a charge against them, which is a behavioral charge for the workplace. And if a shop steward was involved in the process, you're entitled to go through a disciplinary process against that shop steward, because that shop steward, first and foremost, is an employee. It's a little bit of a gray, in fact, it's not a little bit, it's a lot of a gray area, but you need to be resolute and certain as to how you're going to manage that gray area in your workplace. Any questions in this regard? Okay, moving on. Disciplinary protection for shop stewards. Now I've dealt with that. Right. Disciplinary process as it applies to shop stewards. What happens if a shop steward is disciplined for union-related activities? It's considered an unfair labor practice unless those union-related activities are in fact also employee activities. The risks of not consulting the trade union before disciplining a shop steward may lead to legal disputes, but you need to be certain as the company that you're able to distinguish your reason for disciplining him as being an employee and not activities he engaged in as a shop steward. However, you are entitled to do the following. Dear Nahawu or Namza, dear Namza, we are notifying you that your shop steward in front of your members went into an absolute rampage against the CEO of this business and the CFO of this business. And as a result, we have suspended your shop steward, and we wish to ask you to conduct an internal disciplinary inquiry against your own shop steward as a shop steward and inform us of the result and give us an opportunity to state our case as the company. Until that time, until that process is finalized, we are suspending the shop steward on full pay, but not beyond a period of 2 weeks, whereafter we will in fact evict the shop steward from the workplace. You're entitled to do that. So because the guy was on shop steward business, we expect you, the trade union, to deal with your representative on shop steward business. And if you can't deal with him, we will deal with him. That's the message to the trade unions. Can a shop steward claim unfair dismissal if found guilty of misconduct? Only if procedural fairness was not followed. And what's procedural fairness? It's audit ultram partem. Hear both sides of the story. Have a procedurally correct disciplinary inquiry. Have evidence established at the disciplinary inquiry. Prove that misconduct has taken place. And misconduct, this type of and level of misconduct, is not what is expected from any shop steward in any plant environment. So you've got to have your ducks in a row in your audit trail, but only if procedural fairness was not followed can a shop steward claim unfair labor practice. If there was procedural fairness, shop steward doesn't have any ground to stand on. Colleagues, I realize I've gone 5 minutes over. Any thoughts, any concepts, any questions you wish to engage with us on in terms of this brief conversation about how to deal with trade unions and shop stewards in the workplace? There is a document with proper extracts from the Labor Relations Act and applications, which has previously been sent out to you. If you haven't received it, please feel free to ask Tara for it. But any questions, any concerns in this regard?
However, just a quick one from me. I was a bit slow,
How's it,
slow on my
Sharon?
unmute button, so I couldn't get in there in time. But with regards to time off for shop stewards, when they represent at arbitrations, what is that time out of the workplace considered to be? I mean, is it anything special, or is it, yeah, I mean, how do you deal with that?
If there is an arbitration about, if there is an arbitration essentially, which is an appeal against you having exhausted your internal disciplinary process, and an appeal against the finding during the mediation stage, either at the bargaining council or the CCMA, then the shop steward has a right, if the shop steward is a representative, is the representative in that arbitration. If the shop steward is called as a witness, then they don't have a right to be there the whole time, but simply to be called when the evidence is required from them. So an arbitration might take 3 days, but the evidence that the trade union representative wants from the shop steward, or the evidence that another shop steward actually representing the employee wants from that particular shop steward, is going to take 2 to 3 hours. Then reasonableness would be half a day that the shop steward would be entitled, paid to represent the employee, because that's what the rights of representation means, but not to stay in the arbitration for 3 full days. So you're entitled to clarify the role of the shop steward in the arbitration. And if the shop steward is not the main representative, you are in fact entitled to actually say, we want specificity on the amount of time and when that shop steward should in fact be out of that environment. But if your question is, are we obliged to pay? The answer is yes. Because that person is a shop steward and they have rights of representation, including through arbitration, you do have to pay them their normal wage. You do not have to pay transport. You do not have to pay anything other than their normal wage. The rest is up to them.
Good, thanks, Ava.
Any other questions, colleagues?
Maybe just a follow-up from that. That
Yes,
payment to the shop steward, is it classified as part of the shop steward's, say, 10 days annual leave that's in the negotiated agreement, or is it separate to that?
No. So the 10 days annual leave is ordinarily applied for training purposes. In other words, the trade union wants to do training with the employee. You negotiate that you're going to give them a maximum of 10 days a year in total, which, by the way, I think is very generous. I think you should always be starting with no more than 5 and working your way up to 10 based on the trade union proving the point of what training is happening and why it's necessary. But if the trade union applies to you to recognize, the trade union doesn't need to ask you to set off those 10 days. The shop steward is entitled to, it's not time off, is entitled to be deployed into the arbitration because of the right of representation or the right to give evidence. So, Rob, in answer to your question, you have to keep the two separate, training as opposed to representation activities.
Perfect.
On the other hand, hold on. On the other hand, if you have managed to inculcate a culture that says you can represent these employees and we are restricting your rights of representation to taking 10 days in the course of the year, do not walk that back. It's amazing that you've got that. Keep it. Don't walk it back and just go forward as is.
Perfect. The other one that came up, you were talking about shop stewards and their disciplining of shop stewards. if you have a need to suspend a shop steward before the disciplinary action, is there a requirement that you need to engage with the union organizer of the shop steward prior to suspension?
So if you're suspending the shop steward as an employee, in other words, something's gone wrong in their employment, in the course of their employment, then you do not need to negotiate with the trade union, but simply to notify the trade union that the guy's been suspended. If the matter has to do with their behavior as a shop steward, so something happened during the course of a meeting with members, or something happened during the course of an altercation between an employee and a manager, and the shop steward had to get involved and things got out of hand, then you have to notify the trade union before you suspend the individual. You have to have an urgent meeting with the trade union, and then you're entitled, by the way, to say that this is such an urgent matter that if you cannot meet with us today or tomorrow, we are going ahead and suspending him because of the danger he presents in the workplace.
Perfect. Thank you.
Any other questions? All right. Well, guys, thank you very much. And again, I do apologize.
Sorry, Ava.
Yes, Tara.
Can I just ask a question? So some of the small to medium-sized companies within SAPMA don't have trade unions within their workplace currently. So when the minister extends the agreement to non-parties, will they be forced to be part of trade unions, or how would they be able to work out of that?
So to answer your question very simply, an extension of the bargaining council agreement does not require that at a plant level, shop stewards exist. An extension of the bargaining council agreement actually goes the other way and says there is no need for a plant-based agreement, because now what is a voluntary sectoral agreement has become a standard agreement for all companies operating in this industry or in this sector. The purpose of the shop steward is there specifically to represent the individual interest to the company should the company want to discipline or counsel or dismiss. So if there is no active trade union in the company, and because there's no active trade union that has reached sufficient representation of, let's say, 30 or 35 or 40%, then in fact there is no need for a shop steward, because there is no formal engagement with the trade union, and there is no need for a shop steward other than the representation of the people who've joined the trade union. But that's really up to the trade union to organize. So my answer to you, Tara, is if there are no shop stewards, there are no shop stewards. The extension of the agreement doesn't force that a company has to enter into any formalized relationship with a trade union, or in fact have any shop steward present in that company.
Okay, and then the other question that I've got that's come up previously as well, if you do have any company, actually, if it's small, medium, or large, if you do currently have a plant-based agreement, when the minister extends the agreement to non-parties, that current plant-based agreement will be scrapped. It will not be up for negotiation. Is that right?
No. So if a company is not a member of the bargaining council, and then the extension means suddenly they're becoming a member of the bargaining council, the sectoral agreement governs wages and some conditions of employment. But everything else that ordinarily you'd negotiate at a plant level has to continue to be negotiated at a plant level if the parties want it to be. So the plant level agreement is a voluntary agreement. It's not affected by the extension. It might be reduced because of what's automatically now in the compulsory agreement. But the reality is that plant-based agreements will continue if the parties want them to continue, because there's more control over them. Remembering that there are very few conditions of employment covered in any sectoral agreement as it is. And also, the sectoral agreement for a condition of employment might set a floor of a benefit, which then needs to be tweaked in a plant-based agreement to make sense in that company how that floor should operate, and in fact if the floor should be increased or not. So no, a extension doesn't rule out plant-based agreements.
Okay, that's fine. And then just to clarify, from the meeting.
Just hold on to that question about clarification. When the extension takes place, the entire sectoral agreement will be sent to every has to be sent to every company. For example, in SAPMA, has to be sent to every SAPMA member. And what should be pointed out is the schedule at the back of the agreement that says what ordinarily is the purview of the sectoral agreement. So what is sectorally negotiated? We call that collective bargaining. And then what, from a plant-based perspective, should be company bargaining in that plant agreement is also in that schedule. So the schedules to the sectoral agreement in the bargaining council, so the schedule to the industrial chemical sectoral agreement actually specifies what should be dealt with at the plant level and what should be dealt with at the sectoral level. Sorry, Tara.
No, that's fine. I just wanted to clarify the meeting that we had last week with the bargaining council in terms of extensions. So they're waiting for a moratorium to say that they can go ahead from an industrial chemicals agreement point of view. And then they'll send that through to the minister. But are they wanting that agreement to be effective from 1 July 2026, or will they only apply for that extension 1 July 2026?
No,
Because that's the new term of the agreement.
So the reason they want it in place by July of 2026, they'll want it in place earlier, is that the current 2-year sectoral agreement ends in June of next year. And so what they want is that what the bargaining council would like is that any new agreement which is negotiated to replace the one ending in June of next year is extended, has already benefited from the extension of getting to all of SAPMA members rather than just the Surface Coating Employer Association members. That's ideally what they want. What they get, on the other hand, is a completely different thing, because if we are not happy with the terms of the extension, we're not going to agree to the extension. We're quite comfortable that the exemptions process and the SMME phase-in, 3-year phase-in process is now set in concrete. It's there in the policy. We made sure of that. But we might feel that there are other things that need to be negotiated before we agree to the extension. I know that Aggie would want us to jump into the extension straight away. He's said that so many times, but I think we need to be suspicious.
Quite right. You're quite right.
I very much doubt that. Okay, I think that's all from my side. Aggie, I did see your note about you being kicked off for about 5 minutes, but Ava has recorded this, so we'll send you the recording.
Yeah. What happened was the power went off, and then by the time the generators started up, took about 5 minutes for it to be back online again. Sorry
We'll
about
send you
that.
the recording. Any final
Yeah,
questions,
thanks.
colleagues? Any final questions or considerations? None? Okay. Thank you all for joining me. It's been an absolute pleasure and privilege, and I hope you find these information sharing sessions useful. Thank you very much, guys.
Thank you, Iva.
Thank
Thank
you.
you very much. The information
Thanks,
is
Iva.
useful.
Thank
Thank
you,
you so
Iva.
much.
Thank you, guys. Bye-bye.
Thank you.
Okay,
Bye.
bye.
Bye.